Hi, I'm going to be reading the part 2 of the Philippine Legal Doctrines, and if you're not yet subscribed, go ahead and hit that subscribe button and let's study together. Thanks. Doctrine of Supervening Event. The doctrine under which facts and events transpiring after the judgment or order had become final and executory, which circumstances affect or change the substance of the judgment and render its execution inequitable, would justify the suspension or nullification of such final and executory judgment or order. Doctrine of Supervening Negligence. It is also called the doctrine of discovered peril. The doctrine to the effect that where both parties are negligent, but the negligent act of one is appreciably later in time than that of the other, or when it is impossible to determine whose fault or negligence should be attributed to the incident, the one who had the last clear opportunity to avoid the impending harm and failed to do so is chargeable with the consequences thereof. The case of Picard versus Smith, 37 Phil 809. An antecedent negligence of a person does not preclude the recovery of damages for supervening negligence of or bar a defense against the liability sought by another if the latter, who had the last fair chance, could have avoided the impending harm by the exercise of due diligence. Pantranco North Express versus Baeza, 179 Scra 384. Doctrine of the law of the case. That principle under which determination of questions of law will generally be held to govern a case throughout all its subsequent stages, where such determination has already been made on a prior appeal to a court of last resort. It is merely a rule of procedure and does not go to the power of the court, and will not be adhered to where its application will result in an unjust decision. It relates entirely to questions of law, and is confined in its operation to subsequent proceedings in the same case. Villa v. Sandigan, GR 87186, April 24, 1992. Doctrine of the proper law. This is used in a conflict of laws. The doctrine applied in the choice of law stage of a lawsuit involving the conflict of laws. In a conflict lawsuit, one or more state laws will be relevant to the decision-making process. If the laws are the same, this will cause no problems, but if there are substantive differences, the choice of which law to apply will produce a different judgment. Each state, therefore, produces a set of rules to guide the choice of law, and one of the most significant rules is that the law to be applied in any given situation will be the proper law. This is the law which seems to have the closest and most real connection to the facts of the case, and so has the best claim to be applied. Doctrine of the real and hypothecary nature of maritime law. The rule that a ship owner's liability is merely coextensive with his interest in the vessel, except where actual fault is attributable to the ship owner. Aboitiz Shipping Corporation versus CA GR 121833, October 17, 2008. Doctrine of the third group. The doctrine to the effect that the right of the owner of the shares of stock of a Philippine corporation to transfer the same by delivery of the certificate, whether it be regarded as statutory and common law right, is limited and restricted by the express provision that no transfer, however, shall be valid, except as between the parties until the transfer is entered and noted upon the books of the corporation. Uson versus Dio Somito. Doctrine of ultimate consumption. Goods intended for civilian use, which may ultimately find their way and be consumed by belligerent forces, may be seized on the way. Doctrine of ultimate destination. The final destination in the territory of an enemy or under its control, making goods contraband under the doctrine of continuous voyage. Doctrine of Ultravirus, Latin word beyond the powers. The doctrine in the law of corporations that holds that if a corporation enters into a contract that is beyond the scope of its corporate powers, the contract is illegal. Doctrine of Unforeseen Events. The doctrine enunciated by Articles 1267 of the Civil Code, which is not an absolute application of the principle of rebus sic stantibus that would endanger the security of contractual relations. Saw versus Food Fest Land, GR 183628 and 183670. Article 1267 provides when the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom, in whole or in part. Doctrine of Vagueness, an aspect of the due process requirement of notice, which holds that law is facially invalid if persons of common intelligence must necessarily guess as to its meaning and differ as to its application. Doctrine of Vicarious Liability, a legal doctrine that assigns liability for an injury to a person who did not cause the injury, but who has a particular legal relationship to the person who did act negligently. This is also referred as the imputed negligence. Doctrine of Void of Vagueness under constitutional law, the doctrine that is most commonly stated to the effect that a statute establishing a criminal offense must define the offense with sufficient definiteness that persons of ordinary intelligence can understand what conduct is prohibited by the statute. It can only be invoked against that species of legislation that is utterly vague on its face, that is, that which cannot be clarified either by a saving clause or by construction. Estrada versus Sandiganbayan, GR 148560. Compare it with Doctrine of Overbreath. Doctrine of Volenti non fit injuria, the doctrine that refers to self-inflicted injury or to the consent to injury which precludes the recovery of damages by one who has knowingly and voluntarily exposed himself to danger, even if he is not negligent in doing so. Nico Hotel Manila Garden versus Reyes, GR 154259. Doctrine of Waiver, a doctrine resting upon an equitable principle which courts of law will recognize that a person with full knowledge of the facts shall not be permitted to act in a manner inconsistent with his former position or conduct to the injury of another, a rule of judicial policy, the legal outgrowth of judicial abhorrence, so to speak, of a person's taking inconsistent positions and gaining advantages thereby through the aid of courts. Lopez versus Ochoa, GR L7955. Doctrine of Waiver of Double Jeopardy, the doctrine that holds that when the case is dismissed with the express consent of the defendant, the dismissal will not be a bar to another prosecution for the same offense, because his action in having the case dismissed constitutes a waiver of his constitutional right or privilege, for the reason that he thereby prevents the court from proceeding to the trial on the merits and rendering a judgment of conviction against him. People versus Salico. Political Law Doctrines. Archipelagic Doctrine, integration of a group of islands to the sea and their oneness, so that together they can constitute one unit, one country and one state. An imaginary single baseline is drawn around the islands by joining appropriate points of the outermost islands of the archipelago with straight lines, and all islands and waters enclosed within the baseline form part of the territory. The purpose is to protect the territorial interest of an archipelago. Plain view doctrine, the objects within the sight of an officer who has the right to be in a position to have that view are subject to seizure and may be presented as evidence, open to the eye and hand. Doctrine of Indelible Allegiance. An individual may be compelled to retain his original nationality, notwithstanding that he has already renounced or forfeited it under the laws of the second state whose nationality he has acquired. Doctrine of Judicial Supremacy. Although holding neither purse nor sword, and so regarded as the weakest of the three departments of the government, the judiciary is nonetheless vested with the power to annul the acts of either the legislative or the executive department or both when not conformable to the fundamental law. Regalian Doctrine or Jura Regalia. All lands of the public domain, waters, minerals, coal, petroleum, and other minerals, oils, all forces of potential energy, fisheries, forests, or timber, wildlife, flora and fauna, and natural resources belong to the state. With the exception of agricultural lands, all other natural resources shall not be alienated. Stewardship Doctrine. Private property is supposed to be held by the individual only as a trustee for the people in general, who are its real owners. Doctrine of Shifting Majority. For each House of Congress to pass a bill, only the votes of the majority of those present in the session, there being a quorum, is required. Doctrine of Qualified Political Agency or Alter Ego Principle. Acts of the Secretaries of Executive Departments, when performed and promulgated in the regular course of business, or unless disapproved, are presumptively the acts of the Chief Executive. Villena versus Secretary of the Interior. Doctrine of Proper Submission. Plebiscite may be held on the same day as regular election provided the people are sufficiently informed of the amendments to be voted upon to conscientiously deliberate thereon, to express their will in a genuine manner. Submission of piecemeal amendments is constitutional. All the amendments must be submitted for ratification at one plebiscite only. The people have to be given a proper frame of reference in arriving at their decision. They have no idea yet of what the rest of the amended Constitution would be. Tolentino versus Comelec. Doctrines under civil law. Doctrine of Lex Loci Celebrationis. Under this doctrine, the law of the place where contracts, especially a marriage, was made or celebrated governs. In German and Company versus Donaldson, Seaman Company, 1 Phil 63, a power of attorney was executed in Germany giving the recipient authority to bring an action in the Philippines. Said power of attorney was not authenticated by a notary public. In Germany, no such authentication was needed, contrary to Philippines rules. The power of attorney was properly made in so far as form was concerned because it was executed in Germany. There is no reason why Lex Loci Celebrationis should not apply. In Insular Government versus Frank, Mr. Frank, being fully qualified to enter into a contract at the place and time the contract was made, he cannot therefore plead infancy as a defense at the place where the contract is being enforced. Although Mr. Frank was still a minor under Philippine laws, he was nevertheless considered an adult under the laws of the state of Illinois, the place where the contract was made. No rule is better settled in law than that matters bearing upon the execution, interpretation, and validity of a contract are determined by the law of the place where the contract is made. Matters connected to its performance are regulated by the law prevailing at the place of its performance. Matters respecting a remedy, such as bringing of a suit, admissibility of evidence, and statutes of limitations, depend upon the law of the place where the suit is brought. Doctrine of Lex Loci Delicti Commissi. It is the Latin term for law of the place where the delict or tort was committed. In the conflict of laws is the branch of law regulating all lawsuits involving a foreign law element. where a difference in result will occur depending on which laws are applied. The term is often shortened to lex loci delicti. Saudi Arabian Airlines versus CA. With the widespread criticism of the traditional rule of lex loci delicti commissi, modern theories and rules on tort liability have been advanced to offer fresh judicial approaches to arrive at just results. In keeping abreast with the modern theories on tort liability, we find here an occasion to apply the state of the most significant relationship rule, which, in our view, should be appropriate to apply now, given the factual context of this case. In applying said principle to determine the state which has the most significant relationship, the following contracts are to be taken into account and evaluated according to their relative importance with respect to the particular issue. A. The place where the injury occurred. B. The place where the conduct causing the injury occurred. And C. The domicile or residence, nationality, place of incorporation, and place of business of the parties. And finally, the place where the relationship, if any, between the parties is entered or centered. As already discussed, there is basis for the claim that overall injury occurred and lodged in the Philippines. There is likewise no question that private respondent is a resident Filipina national working with petitioner, a resident foreign corporation engaged here in the business of international air carriage. Thus, the relationship between the parties was centered here. Although it should be stressed that this suit is not based on mere labor law violations. From the record, the claim that the Philippines has the most significant contact with the matter in this dispute, raised by the private respondent as plaintiff below against defendant, here in petitioner, in our view, has been properly established. In Nevada et al. Versus Dizon, Jr. et al., Chiquita argues that the court ACO had jurisdiction over the subject matter of the cases filed before them. The amended joint complaint sought approximately $2.7 million in damages for each plaintiff claimant, which amount falls within the jurisdiction of the RTC. Chiquita avers that the pertinent matter is the place of the alleged exposure to DBCP, not the place of manufacture, packaging, distribution, sale, etc. of the said chemical. This is in consonance with the lex loci delicti commissi theory in determining the situs of a tort, which states that the law of the place where the alleged wrong was committed will govern the action. Chiquita and the other defendant companies also submitted themselves to the jurisdiction of the RTC by making voluntary appearances and seeking for affirmative reliefs during the course of the proceedings. None of the defendant companies ever objected to the exercise of the jurisdiction by the courts ACO over their persons. Chiquita thus prays for the remand of civil case numbers 57, 17, and 24 25196 to the RTC of General Santos City and the RTC of Davao City, respectively. Doctrine of lex loci re cite. It is the Latin term for law of the place where the property is situated. It is a doctrine which states that the law governing the transfer of title to property is dependent upon and varies with the location of the property for the purposes of the conflict of laws. Conflict is the branch of public law regulating all lawsuits involving a foreign law element where a difference in result will occur depending on which laws are applied. Wells Fargo Bank and Union Trust Company versus the Collector of Internal Revenue. He extended his activities with respect to his intangibles so as to avail himself of the protection and benefits of the laws of the Philippines in such a way as to bring his person or property within the reach of the Philippines. The reason for a single place of taxation no longer obtains protection, benefit, and power over the subject matter are no longer confined to California but also to the Philippines. In the instant case, the actual situs of the shares of stock is in the Philippines, the corporation being domiciled therein, and besides, The certificates of stock have remained in this country up to the time when the deceased died in California, and they were in possession of one Serena McKee, Secretary of the Benguet Consolidated Mining Company, to whom they have been delivered and endorsed in the bank. This endorsement gave Serena McKee the right to vote the certificates at the general meetings of the stockholders, to collect dividends and dispose of the shares in the manner she may deem fit, without prejudice to her liability to the owner for violation of instructions. For all practical purposes, then, Serena McKee had the legal title to the certificates of stock held in trust for the true owner thereof. In other words, the owner residing in California has extended her activities with respect to her intangibles so as to avail herself of the protection and benefit of the Philippine laws. Accordingly, the jurisdiction of the Philippine government to tax must be upheld. Manila Gas Corporation versus Collector of Internal Revenue, the absence of flight operations to and from the Philippines is not determinative of the source of income or the situs of income taxation. The test of taxability is the source, and the source of an income is that activity which produced the income. Unquestionably, the passage documentations in these cases were sold in the Philippines, and the revenue therefrom was derived from a business activity regularly pursued within the Philippines. The word source conveys one essential idea, and that of origin, and the origin of the income herein is the Philippines. The Operative Fact Doctrine. The law is recognized as unconstitutional, but the effects of the unconstitutional law prior to its declaration of nullity may be left undisturbed as a matter of equity and fair play. In fact, the invocation of the Operative Fact Doctrine is an admission that the law is unconstitutional. In Planters Products versus Fertifiel Corporation, the doctrine of operative fact, as an exception to the general rule, only applies as a matter of equity and fair play. It nullifies the effects of an unconstitutional law by recognizing that the existence of a statute prior to a determination of unconstitutionality is an operative fact and may have consequences which cannot always be ignored. The past cannot always be erased by a new judicial declaration. The doctrine is applicable when a declaration of unconstitutionality will impose an undue burden on those who have relied on the invalid law. Thus, it was applied to a criminal case when a declaration of unconstitutionality would put the accused in double jeopardy or would put in limbo the acts done by a municipality in reliance upon a law creating it. In Francisco Chavez versus National Housing Authority, when the petitioner filed the case, the JVA had already been terminated by virtue of MOA between RBI and NHA. The properties and rights in question, after the passage of around 10 years from the start of the project's implementation, cannot be disturbed or questioned. The petitioner, being the Solicitor General of the time, as MDRP was formulated, had ample opportunity to question the said project but did not do so. The moment to challenge has passed. Doctrine of Relations. That principle of law by which an act done at one time is considered by a fiction of law to have been done at some antecedent period. It is a doctrine which, although of equitable origin, has a well-recognized application to preceding law. A legal fiction invented to promote the ends of justice or to prevent injustice and the occurrence of injuries where otherwise there would be no remedy. The doctrine, when invoked, must have connection with actual fact, must be based on some antecedent, lawful rights. It has also been referred to as the doctrine of relation back. In Alhambra, Sigra versus Secretary, DRL 23606, since the privilege of extension is purely statutory, all of the statutory conditions precedent must be complied with in order that the extension may be effectuated. And generally, these conditions must be complied with, and the steps necessary to effect the extension must be taken during the life of the corporation and before the expiration of the term of existence as originally fixed by its charter or the general law, since, as a rule, the corporation is ipso facto dissolved as soon as that time expires. So, where the extension is by amendment of the Articles of Incorporation, the amendment must be adopted before that time. And similarly, the filing and recording of a certificate of extension after that time cannot relate back to the date of the passage of a resolution by the stockholder in favor of the extension, so as to save the life of the corporation. The contrary is true, however, that the doctrine of relation will apply where the delay is due to the neglect of the officer with whom the certificate is required to be filed, or to a wrongful refusal on his part to receive it, and statutes in some states specifically provide that a renewal may be had within a specified time before or after the time fixed for the termination of the corporate existence. Fair use doctrine. The general public is given the right to reproduce a work subject to specific limitations. Under Philippine law, fair use of a work for criticism, comment, news, reporting, teaching, including multiple copies for classroom use, scholarship, research, and similar purposes, does not infringe copyright. Fair use has exact definition under the law. However, authorities have agreed on the following criteria enumerated in Section 18.5.1 of the Code. The purpose and character of the use, including whether such use is of a commercial nature or as non-profit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for the value of the copyrighted work. Traditionally, fair use is more easily accepted when the purpose of copying is educational in character and purpose than when it is commercial or for profit. It does not mean, however, that all copying for educational or classroom purposes is fair use. The Philippines has not had any case brought before the court to challenge fair use in this context. To illustrate the point, we must draw on American court decisions. In Princeton University versus Michigan Document Service, U.S. court did not consider photocopying of materials for compilation in course packs as fair use because photocopying was done by a commercial vendor. On the other hand, in another case, the U.S. court tended towards the more fundamental aim of protecting the progress of science and the arts. In Williams versus Wilkins, it gave the opinion that medical science would be seriously hurt if library photocopying was stopped. Fros et jus nunquam cohabitat. Fraud and justice never agree together, a maxim meaning that fraud corrupts justice regardless of the good faith or just intentions. In Republic versus CA, we are well aware of the rule reiterated in Republic versus Court of Appeals and Santos that generally the state cannot be put and stopped by the mistakes or errors of its officials or agents. In that very case, however, citing 31 CJS 675676, we went further by saying, nevertheless, the government must not be allowed to deal dishonorably or capriciously with its citizens and must not play an ignoble part or do a shabby thing and subject to a limitation. The doctrine of equitable estoppel may be invoked against public authorities as well as against private individuals. In Republic of the Philippines versus Gregorio Agunoy Seniors et al., spoused Eduardo and Arcelita Marquez and Royal Bank of Japan, in any event, the verification survey conducted by geodetic engineer Melencio Mangajas on February 15 came almost 22 years after the February 28, 1966 certification of Jose Mendigoria more than 21 years after the issuance of Agonoy Sr.'s free patent number 341150 on January 18, 1967, and its registration as original certificate of title on February 6, 1967, and more than 8 years reckoned from July 31, 1979, when upon the death of the wife of Gregorio Agonoy Sr., the heirs executed a deed of extrajudicial partition with sale in favor of Joaquin Sangabol. In the meantime, for about half a decade thereafter, ownership over the properties transferred from one buyer to another, with each and every transferee enjoying the presumption of good faith. If only on this score alone the present petition must fail. There can be no debate at all on petitioner's submission that no amount of legal technicality may serve as a solid foundation for the enjoyment of the fruits of fraud. It is thus understandable why petitioner chants the dogma of fros et jus nunquam cohabitat. Significantly, however, in the cases cited by Petitioner Republic, as well as in those other cases where the doctrine of fros et jus nunquam cohabitat was applied against a patent and title procured through fraud or misrepresentation, we note that the land covered thereby is either a part of the forest zone, which is definitely non-disposable, as in animas, or that said patent and title are still in the name of the person who committed the fraud or misrepresentation, as in Acot Animas, Republic versus CA, and Del Mundo and Director of Lands versus Abanil et al. And in either instance, there were no innocent third parties standing in the way. Here it bears stressing that by petitioner's own judicial admission, the lots in dispute are no longer part of the public domain, and there are numerous third, fourth, fifth, and more parties holding Torrens title in their favor and enjoying the presumption of good faith. This brings to mind that what we have re-echoed in Pino versus Court of Appeals and the cases therein cited. Even on the supposition that the sale was void, the general rule that the direct result of a previous illegal contract cannot be valid on the theory that the spring cannot rise higher than its source cannot apply here, for we are confronted with the functionings of the Torrens system of registration. The doctrine to follow is simple enough. A fraudulent or forged document of sale may become the root of a valid title if the certificate of title has already been transferred from the name of the true owner to the name of the forger or the name indicated by the forger. It is even worse in this case because here there is no forger to speak of. The remark of Land Inspector Jose Mendigoria about the abandonment by Eusebio Perez and Valenciano Espiritu cannot by itself be fraudulent. And for all we know, that remark may even turn out to be the truth. What petitioners perceive as fraud may be nothing more than the differences of professional opinions between Land Inspector Jose Mendigoria and Geodetic Engineer Melencio Mangajas. But regardless of who between the two is correct, the hard reality is that the properties in question are no longer floating objects on a spring that cannot rise higher than its source, as they are now very much ashore and firmly standing on the high solid ground of the Torrens system of land registration. Nemo dat quod non habet, literally meaning no one gives what he doesn't have in legal rule, sometimes called the Nemo dat rule, that states that the purchase of a possession from someone who has no ownership right to it also denies the purchaser any ownership title. Also, when goods are sold by a person who is not their owner and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods than the seller had, unless the owner of goods is by his conduct precluded from denying the seller's authority to sell. In Igao versus CA, GRL 79787, deeds of sale of patented lands perfected within the prohibited 5-year period are null and void. Section 124 Public Land Act. No title passed from the Igaos to Marfori, which could be validly transferred to herein respondents Bontilao and Dignos, Nemo that could none habet. Nobody can dispose of that which does not belong to him. While the government has not taken steps to assert its title by reversion to a homestead sold in violation of the Public Land Act, the vendor or his heirs is better entitled to the possession of the said, the vendee being in no better situation than any intruder. Accordingly, respondents who are not innocent purchasers for value have no standing to question petitioner's right to the land and to file an action for quieting of title. Indelible versus Ferrer, since the donation in this case was one made inter vivos, it was immediately operative and final. The reason is that such kind of donation is deemed perfected from the moment the donor learned of the donor's acceptance of the donation. The acceptance makes the donee the absolute owner of the property donated. Given that the donation in this case was irrevocable or one given inter vivos, Leopoldo's subsequent assignment of his rights and interest in the property to Assumption should be regarded as void, for by then he had no more rights to assign. He could not give what he no longer had, nemo that quod non habet. The trial court cannot be faulted for passing upon, in a petition for probate of what was initially supposed to be a donation mortis causa, the validity of the document as a donation inter vivos and the nullity of one of the donor's subsequent assignment of his rights and interest in the property. The court has held before that the rule on probate is not inflexible and absolute. Moreover, in opposing the petition for probate and in putting the validity of the deed of assignment squarely in issue, Assumption, or those who substituted her, may not now claim that the trial court improperly allowed a collateral attack on such assignment. Doctrine of Processual Presumption. Where a foreign law is not pleaded, or even if pleaded is not proved, the presumption is that foreign law is the same as ours. In the case of ATSI Overseas Corporation, Amalia G. Iqdal and Ministry of Public Health, Kuwait versus Maria Josefa Etchin, GR 178551, October 11, 2001, in the present case, the employment contract signed by Gran specifically states that Saudi labor laws will govern matters not provided for in the contract, that is, or example, specific causes for termination, termination procedures, etc. Being the law intended by the parties, lex loci intentionis, to apply to the contract, Saudi labor laws should govern all matters relating to the termination of the employment of Gran. In international law, the party who wants to have a foreign law applied to a dispute or case has the burden of proving the foreign law. The foreign law is treated as a question of fact to be properly pleaded and proved, as the judge or labor arbiter cannot take judicial notice of a foreign law. He is presumed to know only domestic or forum law. Unfortunately for petitioner, it did not prove the pertinent Saudi laws on the matter. Thus, the international law doctrine of presumed identity approach or processual presumption comes into play. In Northwest Orient Airlines Incorporated versus Court of Appeals and C.F. Sharp and Company, GR number 112573. Alternately, in the light of the absence of proof regarding Japanese law, the presumption of identity or similarity or the so-called processual presumption may be invoked. Applying it, the Japanese law on the matter is presumed to be similar with the Philippine law on service of summons on a private foreign corporation doing business in the Philippines. Section 14, Rule 14 of the Rules of Court provides that if the defendant is a foreign corporation doing business in the Philippines, service may be made 1. On its resident agent designated in accordance with law for that purpose, or 2, if there is no such resident agent on the government official designated by law to that effect, and 3, on any of its officers or agents within the Philippines. Inasmuch as Sharp was admittedly doing business in Japan through its 4 duly registered branches at the time the collection suit against it was filed, then in the light of the processual presumption, Sharp may be deemed a resident of Japan, and as such was amenable to the jurisdiction of the courts therein, and may be deemed to have assented to the said court's lawful methods of serving process. Accordingly, the extraterritorial service of summons on it by the Japanese court was valid not only under the processual presumption, but also because of the presumption of regularity of performance of official duty. Unjust enrichment. The principle that no person may unjustly enrich himself at the expense of another, nemo cum alterius detrimento locupletari potest, is embodied in Article 22 of the New Civil Code. There is unjust enrichment when 1. A person is unjustly benefited, and 2. Such benefit is derived at the expense of or with damages to another. The main objective of the principle of unjust enrichment is to prevent one from enriching oneself at the expense of another. It is commonly accepted that this doctrine simply means that a person shall not be allowed to profit or enrich himself unequitably at another's expense. In Chiang versus Spouses Santos, GR 169647, the principle of unjust enrichment obliges the respondents to pay the remaining balance of the loan plus interest. Relieving the respondents of their obligation to pay the balance of the loan would indeed be to sanction unjust enrichment in favor of respondents and cause unjust poverty to petitioner. In the exercise of our mandate as a court of justice and equity, we hold pro hoc vice that respondents are still liable to pay the remaining balance of the loan. Respondents Eulogio and Teresita Santos are hereby ordered to pay petitioner Antonio Chiang, substituted by William Chiang, the balance of the loan amounting to 93,000 plus legal interest of 12% per annum from July 30, 1992 up to the finality of this decision, and an additional legal interest of 12% per annum from the finality of this decision up to its satisfaction. Pari delicto, a doctrine that provides that court will not enforce an invalid contract and that no party can recover in an action where it is necessarily to prove the existence of an illegal contract in order to make his or her case. In the case of Hust versus Pierre Builders, GR 156364, September 3, 2007, a universal doctrine which holds that no action arises in equity or at law from an illegal contract, no suit can be maintained for its specific performance or to recover the property agreed to be sold or delivered, or the money agreed to be paid, or damages for its violation, and where the parties are in pari delicto, no affirmative relief of any kind will be given to one against the other. This rule, however, is subject to exceptions that permit the return of that which may have been given under a void contract. 1. The innocent party. 2. The debtor who pays the usurious interest. 3. The party repudiating the void contract before the legal purpose is accomplished, or before damage is caused to a third person, and his public interest is subserved by allowing recovery. Next, the incapacitated party, if the interests of justice so demands. Next, the party for whose protection the prohibition by law is intended if the agreement is not illegal per se, but merely prohibited, and if public policy would be enhanced by permitting recovery. And F, the party for whose benefit the law has been intended, such as in price ceiling laws. In Menchavis versus Teves, a void contract is deemed legally non-existent. It produces no legal effect. As a general rule, courts leave parties to such a contract as they are because they are in pari delicto or equally at fault. Neither party is entitled to legal protection. A void contract is equivalent to nothing. It produces no civil effect. It does not create, modify, or extinguish a juridical relation. Parties to a void agreement cannot expect the aid of the law. The courts leave them as they are because they are deemed in pari delicto or in equal fault. To this rule, however, there are exemptions that permit the return of that which may have been given under a void contract. One of the exemptions is found in Articles 1412 of the Civil Code, which states that if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. When the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract or demand the performance of the other's undertaking. Number two, when only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract or ask for the fulfillment of what has been promised him. The other who is not at fault may demand the return of what he has given without any obligation to comply with his promise. On this premise, respondent contends that he can recover from petitioners because he is an innocent party to the contract of lease. Petitioners allegedly induced him to enter into it through serious misrepresentation. Res ipsa loquitur, Latin for the thing speaks for itself, a doctrine of law that one is presumed to be negligent if he or she or it had exclusive control of whatever caused the injury, even though there is no specific evidence of an act of negligence, and without negligence the accident would not have happened. In Professional Services Incorporated versus Agana, TR 126297, 2007, it is the rule that the fact that the occurrence of an injury taken with the surrounding circumstances may permit an inference or raise a presumption of negligence or make out a plaintiff prima facie case and present a question of fact for a defendant to meet with an explanation. Stated differently, where the thing which caused the injury without the fault of the injured is under the exclusive control of the defendant and the injury is such that it should not have occurred if he, having such control, used proper care. It affords reasonable evidence, in the absence of explanation, that the injury arose from the defendant's want of care, and the burden of proof is shifted to him to establish that he has observed due care and diligence. From the foregoing statements of the rule, the requisites for the applicability of the doctrine of res ipsa loquitur are: 1. The occurrence of an injury. 2. The thing which caused the injury was under the control and management of the defendant. 3. The occurrence was such that in the ordinary course of things would not have happened if those who had control or management used proper care. And 4th, the absence of explanation by the defendant. Of the foregoing requisites, the most instrumental is the control and management of the thing which caused the injury. In this jurisdiction, res ipsa loquitur is not a rule of substantive law. Hence, does not per se create or constitute an independent or separate ground of liability, being a mere evidentiary rule. In other words, mere invocation and application of the doctrine does not dispense with the requirement of proof of negligence. In Joaquinita P. Capilli versus Spouses Dominador Cardania and Rosita Cardania, the fact, however, that respondent's daughter Jasmine died as a result of the dead and rotting tree within the school's premises shows that the tree was indeed an obvious danger to anyone passing by and calls for application of the principle of res ipsa loquitur. The doctrine of res ipsa loquitur applies when 1. The accident was of such character as to warrant an inference that it would not have happened except for the defendant's negligence. 2. The accident must have been caused by an agency or instrumentality within the exclusive management or control of the person charged with the negligence complained of. And 3. the accident must not have been due to any voluntary action or contribution on the part of the person injured. In the case of DM Kansuni versus Court of Appeals, the court held, as a rule of evidence, the doctrine of res ipsa loquitur is peculiar to the law of negligence, which recognizes that prima facie negligence may be established without direct proof and furnishes a substitute for specific proof of negligence. The concept of res ipsa loquitur has been explained in this wise. While negligence is not ordinarily inferred or presumed, and while the mere happening of an accident or injury will not generally give rise to an inference or presumption that it was due to negligence on defendant's part, under the doctrine of res ipsa loquitur, which means literally the thing or transaction speaks for itself, or in one jurisdiction that the thing or instrumentality speaks for itself, the facts or circumstances accompanying an injury may be such as to raise a presumption or at least permit an inference of negligence on the part of the defendant, or some other person who is charged with negligence, where it is shown that the thing or instrumentality which caused the injury complained of was under the control or management of the defendant, and that the occurrence resulting in the injury was such as in the ordinary course of things would not happen if those who had its control or management used proper care. There is sufficient evidence, or as sometimes stated, explanation by the defendant that the injury arose from or was caused by the defendant's want of care. The procedural effect of the doctrine of res ipsa loquitur is that petitioner's negligence is presumed once respondents established the requisites for the doctrine to apply. Once respondents made out a prima facie case of all requisites, the burden shifts to petitioner to explain. The presumption or inference may be rebutted or overcome by other evidence, and under appropriate circumstances, a disputable presumption, such as that of due care or innocence, may outweigh the inference. Ignorantia legis non excusat. It is a Latin maxim meaning ignorance of the law is not an excuse to a criminal charge. The purpose of this maxim is that if ignorance is considered an excuse, a person charged with criminal offense or a subject of a civil lawsuit would merely claim that he or she is unaware of the law in question to avoid liability. Ignorantia juris non excusat is also known as ignorantia legis non excusat. In the case of Agustin de Luna et al. Versus Jose Linatok, GR 48403, October 28, 1942, mistake of law does not make a contract voidable, because ignorance of the law does not excuse anyone from its compliance. That the petitioners did not know the prohibition against partition of the conjugal partnership property during marriage is no valid reason why they should ask for the annulment of the sales made Exhibit C and D and recognized in Exhibit I. In the case of United States versus Achong, the question then squarely presents itself whether in this jurisdiction one can be held criminally responsible who, by reason of a mistake as to the fact, does an act for which he would be exempt from criminal liability if the facts were as he supposed them to be, but which would constitute a crime of homicide or assassination if the actor had known the true state of the facts of the time when he committed the act. To this question, we think there can be but one answer, and we hold that under such circumstances there is no criminal liability, provided always that the alleged ignorance or mistake of fact was not due to negligence or bad faith. In broader terms, ignorance or mistake of fact, if such ignorance or mistake of fact is sufficient to negate a particular intent, which under the law is a necessary ingredient of the offense charge, that is, in larceny, animus furendi, in murder, mistake, malice, in crimes, intent, cancels the presumption of intent, and works an acquittal, except in those cases where the circumstances demand a conviction under the penal provisions. touching criminal negligence, and in cases where under the provisions of Article 1 of the Penal Code, one voluntarily committing a crime or misdemeanor incurs criminal liability for any wrongful act committed by him, even though it be different from that which he intended to commit. Doctrine of lex nationali. Citizenship is the basis for determining the personal law applicable. Article 15 of the Civil Code provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. This is the rule of lex nationali in private international law. Thus, the Philippine state may require for effectivity in the Philippines recognition by Philippine courts of a foreign judgment affecting its citizen, over whom it exercises personal jurisdiction relating to the status, condition, and legal capacity of such citizen. Regardless of where a citizen of the Philippines might be, he or she will be governed by the law of his nationality, Philippine laws, with respect to his or her family rights and duties or to his status, condition, or legal capacity. In Juan Misiano versus Andre Brimo, November 1927, that's a long time ago, though the last part of the second clause of the will expressly said that it be made and disposed of in accordance with the laws in force in the Philippine island, this condition, described as impossible conditions, shall be considered as not imposed and shall not prejudice the ear of the legatee in any manner whatsoever, even should the testator otherwise provide. Impossible conditions are further defined as those contrary to law or good morals. Thus, national law of the testator shall govern in his testamentary dispositions. The court approved the scheme of partition submitted by the judicial administrator in such manner as to include Andrew or Andre Primo as one of the legatees. In Bellis versus Bellis, the Supreme Court held that the said children are not entitled to their legitimes under the Texas law, being the national law of the deceased. There are no legitimes. The parties admit that the decedent Amos G. Bellis was a citizen of the state of Texas, USA, and that under the laws of Texas, there are no forced heirs or legitimes. Accordingly, since the intrinsic validity of the provisions of the will and the amount of successional rights are to be determined under Texas law, the Philippine law on legitimes cannot be applied to the testacy of Amos Bellis. Article 16, paragraph 2 and Article 1039 of the Civil Code render applicable the national law of the decedent. In intestate or testamentary successions, with regard to 4 items: the order of succession, the amount of successional rights, the intrinsic validity of the provisions of the will, and the capacity to succeed. Intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. Whew! Time check, it's midnight. Let's pick up from here for part 3. And if you're not yet subscribed, go ahead and hit the subscribe button. Let's study together. Thanks.